Namaste friends, welcome back to my channel Advocate Pramod Bhardwaj Speaks. I'm Advocate Pramod Kumar Bhardwaj, and in today's video we discuss something that is very important, especially in criminal cases, bail. Bail is something that you may have heard about but may not fully understand, especially when it comes to how it works in serious criminal cases. If you have ever wondered how the law handles situations where someone is arrested and what happens next, this video is for you. Whether it's a high profile case or something that's happening in your neighborhood, the issue of bail can determine if an accused person stays in jail or gets released while waiting for trial. Today, we'll focus on how bail works in two types of offenses: cognizable offenses and non-cognizable offenses. Let's break it down so that it's easy to understand for everyone. First, let's start with the basics. What is bail? Bail is the temporary release of an accused person, usually when they are waiting for their trial to begin or during the trial. In simple terms, it means the person doesn't have to stay in jail until the trial or court hearings are completed. Instead, they are released under certain conditions, such as paying some amount of money or promising to show up for court dates. However, not everyone who is arrested automatically gets bail. Whether someone gets bail or not depends on seriousness of the offenses they have been charged with. There are two main types of criminal offenses in Indian law: cognizable and non-cognizable offenses. Let's look at these in more detail. Let's first discuss cognizable offenses in bail. When we talk about cognizable offenses, we are referring to serious crimes like murder, rape, kidnapping, robbery, etc. These are crimes where police have the power to arrest a person without warrant and start investigating right away. These offenses are considered to be a threat to public safety, so the law is stricter when it comes to granting bail. If someone is arrested for a cognizable offense, they don't have an automatic right to bail. In many cases, bail may be denied, especially if the crime is very serious and if there's a chance the accused might try to influence, witness, or flee from the country. However, bail can still be granted, but it depends on the facts of the case, including the severity of the crime, the nature of the evidence, and the accused person's background. For example, if the person has a history of criminal activity or if there's a risk that they might repeat the crime, bail is less likely to be granted. The court also looks at whether there's a genuine fear that the accused will tamper with the evidence or intimidate witnesses. Next, non-cognizable offenses and bail. Let's talk about non-cognizable offenses. These are crimes that are considered less serious than cognizable offenses. Examples include minor theft, defamation, or simple assault. In these cases, the police do not have the authority to arrest the accused without a warrant, and the investigation can only start with permission from a magistrate. When it comes to non-cognizable offenses, the accused person is much more likely to get the bail. These offenses are less of a threat to society, so the law is more lenient. The court will generally grant bail without much hassle unless there are exceptional circumstances or if the accused has a history of causing harm or repeating crimes. For non-cognizable offenses, bail is almost a given, but even then, the judge may look into the situation and consider things like whether the accused is likely to flee the law or if the accused has caused harm in the past that could suggest a risk to others. Bail in non-bailable offenses. You might have heard the term non-bailable offenses being used in the news. Non-bailable offenses refer to serious crimes where the person arrested does not have an automatic right to be granted bail. These are usually crimes like murder, terrorism-related offenses, or other acts that involve grave harm to society. Even though an accused person in a non-bailable offense may not have an automatic right to bail, it doesn't mean that they are never granted bail. The court still has the power to grant bail based on the situation and facts of the case. The judge will assess whether the accused is likely to flee, influence the case, or harm anyone else. The court will also look at the circumstances surrounding the crime, the evidence, and the accused person's background. So while the law is more strict about granting bail for non-bailable offenses, the judge still has some flexibility and can decide to grant bail if the circumstances are right. This decision is very important because it impacts whether the accused stays in jail or is released until the trial is finished. So, what do the courts consider before granting bail? When a person applies for bail, whether in a cognizable or non-cognizable offense, the court considers several factors. Let's take a quick look at some of them. First, the severity of the crime. If the crime is very serious, the chances of getting bail are lower. For example, a murder charge would be harder to get bail for than a petty theft charge. 2. Risk of fleeing or influencing the investigation. The courts look at whether the accused is likely to run away from the law or try to interfere with the investigation by influencing witnesses or destroying evidence. Third, background of the accused. If the person has a clean record or a first-time offender, they may be granted bail more easily. If they have a history of criminal activity, the court may be more hesitant. For public safety, if releasing the accused person poses a threat to public safety or causes fear among the public, bail may be denied. Next comes judicial discretion. A key point to remember is that bail is ultimately up to the court's discretion. The judge will carefully consider all factors before making a decision. This means that even though the law provides guidelines, the final decision can vary from case to case. So, why is bail important? You may be wondering why bail is such an important part of the criminal justice system. Well, the principle behind bail is that a person is innocent until proven guilty. The law assumes that everyone has the right to freedom while they await their trial unless there are strong reasons to keep them in jail. Bail allows people to continue their lives and jobs while the trial process takes place, rather than being stuck in jail for an extended period. In conclusion, bail is a vital part of the legal system in our country, and it plays a major role in how the justice system handles accused individuals. Whether it's a serious crime or a less severe one, the question of whether someone gets bail can have significant consequences. By understanding the difference between cognizable and non-cognizable offenses and how the courts make decisions about bail, we can better appreciate how the law works and why it matters in the criminal justice system. I hope this video has cleared some of your doubts about the bail, and if you found this information helpful, don't forget to like, share and subscribe to my channel for more content. If you have any questions or thoughts, contact me through WhatsApp or email provided in the description below. Thanks for watching and see you next time.